Virtual disappearance of jail.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Mr. Miller, will you state your name for the record?
Dale Joseph Miller, the Alpha and Omega.
Before we even get into the heart of this courtroom exchange, you can already sense that this hearing is about to take a very unusual turn. At first glance, it seems like a fairly standard procedural moment. Defense counsel stepping forward, the judge preparing to address the defendant, and the court simply confirming the case on record. But in criminal courtrooms, especially in competency hearings, the calm opening moments can quickly spiral into something far more dramatic. And that's exactly what happens here. This case centers on Mr. Dale Joseph Miller, a defendant who has already been evaluated by mental health professionals and deemed incompetent to stand trial, but potentially restorable with treatment. That phrase, incompetent but restorable, is extremely important in the legal system. It means the court believes the defendant currently cannot assist in his own defense or understand the proceedings, but there is a possibility that medical treatment could restore that competency. So instead of moving forward with trial, the court must first determine whether the defendant should be sent for psychiatric treatment at a forensic center. But here's where things become extraordinary. Instead of quietly participating in the process, Mr. Miller begins making claims that completely derail the normal courtroom flow. Claims involving divine identity, biblical prophecy, and global figures. Moments like this are rare, but they reveal a critical function of the justice system. Courts must balance due process, mental health evaluation, and public safety all at the same time. And as this hearing unfolds, the judge will have to navigate not just legal procedure, but a situation that quickly becomes one of the most surreal courtroom exchanges you'll see.
Will you give this to him, please?
Probably not, but I'll look at it first.
Okay.
Thanks. Judge, Mr. Miller was found incompetent but restorable.
Yes.
The opinion that I have has this case also listed on it. I'm not sure. I think maybe
What's your date of your report?
I want to say it was like May 6th.
I have a May 8th report.
Okay, May 8th.
I'm opining that he's incompetent to stand trial, but likely to obtain competence was the proper course of treatment.
Correct. So I don't know if this one just got behind the other three, but I have an order prepared.
All right.
The court to sign. He's awaiting treatment at the forensic center. And just for the court's information, his next review date on those other three matters are the 14th of August.
Am I allowed to speak real quick?
No, I wouldn't recommend that.
I just want to let you know I'm the original son of God, the Alpha and Omega, mighty God, the only child conceived from Yahweh, Angelica, and the Holy Spirit. The devil is inside Barack Obama, Azazel. He was at Area 51. Semyaza, his sidekick, is inside Pope Francis. The book of Revelation is about me, and I have 12 sisters that are down here too.
This moment is exactly why the court previously determined that Mr. Miller was incompetent to stand trial. What you just heard is not simply a disruptive outburst. It is the kind of statement that courts and mental health professionals look at very closely when evaluating competency. When a defendant claims to be the Alpha and Omega, the Son of God, Creator of Heaven, and the central figure in the book of Revelation, that immediately raises red flags for delusional thinking. And legally speaking, competency is not about whether someone committed the crime. It's about whether they can understand the charges, the courtroom process, and assist their attorney in their defense. If someone genuinely believes they are a divine figure orchestrating world events, it becomes extremely difficult for them to meaningfully participate in a legal defense. Notice how the judge handles this situation. He doesn't engage with the statements or challenge them directly. Instead, he calmly moves the proceedings forward. That's intentional. Judges are trained not to debate defendants during competency hearings, because doing so can escalate the situation and derail the hearing. What's really happening behind the scenes is procedural. The court is preparing to send Mr. Miller to a forensic psychiatric facility where doctors will attempt to stabilize him through treatment. And here's the question for viewers. Do you think situations like this should be handled strictly through mental health treatment, or should courts still move forward with criminal proceedings regardless?
Christ comes from me in heaven too. I sent him into this world. I created the heaven and the angels. Azazel kissed my wife Danielle twice in heaven. That's why he was put down here. He caused the fall, sending a male into the Garden of Eden to sleep with Eve. So he's paying the price now, and he is going to be dealt with soon. I'm going back to heaven soon. The rapture is going to happen soon, and I will come back after 7 years. I'm the Alpha and Omega, the Lion of Judah. Christ is the Lamb of God. I put everything in that note she's supposed to give you, but you guys won't let me speak. Lauren, the girl this case is over, is one of my 12 sister wives,
Okay,
Not the case.
and
all right. I know,
I'm letting you know, you guys
About
haven't
the
given me a
case.
chance to
Let's
defend myself. I
talk.
try to let you know.
I let you talk, but now I'm done.
Okay,
Okay.
been warned. You will be dealt with. I'm the real judge of this world.
Okay.
You're
I'll-
going to
I'll,
hell.
I'll await that.
Thank you.
September 4th for 2025, 9 a.m. Round continue. You know, I've heard that same thing from Feaster. Every conversation I have with him. Every conversation with Feaster starts that way. I don't really think it's up to you. Court calls the case, people versus our leash.
Mr. Brumfield, could you state your full name?
Ryan Brumfield.
Now we transition to a completely different case in the same courtroom session, and the tone shifts dramatically from mental competency issues to something far more procedural: bond violations. Bond conditions are essentially a promise to the court. When a defendant is released before trial, they must follow specific rules. Things like appearing for court dates, avoiding new crimes, and complying with testing requirements. In this case, Mr. Brumfield's situation revolves around two alleged violations. First, there's the failure to test on a SoberLink device. These devices are often used in alcohol monitoring cases. The defendant is required to regularly submit breath tests to confirm sobriety. Missing those tests can be interpreted by the court as either non-compliance or an attempt to avoid detection. Second, there's an allegation involving taking food from the University of Michigan Hospital, which could potentially lead to new criminal charges. Now the defense attorney is attempting a common legal strategy: requesting a personal recognizance bond, often called a PR bond. That means the defendant would be released based solely on a promise to appear in court, without paying money, while possibly wearing a scram tether, which continuously monitors alcohol consumption. But the judge now has to weigh two competing concerns: the defendant's right to pretrial freedom versus the risk that the defendant will continue violating court orders. And as you're about to hear, the prosecution strongly pushes back.
And Your Honor, I do have a green sheet here. I am asking for an adjournment. I was not aware that Mr. Brumfield was in custody until this morning, so I would need some time to go over discovery with him. And I would again like to address.
And you're also, you want to address this bond? Have you seen the new complaint for conditional bond violation?
I have.
Okay, go ahead.
Your Honor, Mr. Brumfield was just arraigned last week. I do understand that there were two violation reports filed, one for a failure to test on the SoberLink device that was ordered, and the other for a new complaint with the allegation that Mr. Brumfield allegedly took some food from the University of Michigan Hospital. I would still ask Your Honor to consider a personal recognizance bond here with a scram tether rather than a SoberLink. I think that might be easier for Mr. Brumfield to test. And it's my understanding that
Are there new charges that are going to be coming from that?
Your Honor, as it's just new, we have not received a new warrant request yet.
Got it.
Receiving it shortly.
Yes, and it's my understanding that he's not being held on anything to do with the new report.
Any response from the people?
Your Honor, we would reject the defendant's release at this time, considering the two separate bond violations with the criminal history that does include fraud and his prior illegal lies. If you were considering his release, we would ask for that scram tether, considering that he did not test at all on his sober.
That's part of the problem. He didn't test, and that is allegedly out there, at least, or places himself in a position where he's committed another offense.
I understand, Your Honor, and I think the scram tether would solve that testing issue. And I would just emphasize that it was just a few days that he was not testing. I did attempt to reach out to him when I found out, but I believe we just didn't have updated contact information for him. Would still ask the court to consider a personal bond and a scram.
Motion for bond reduction is denied.
This is a decisive moment in the hearing. When the judge says motion for bond reduction denied, it means the court is not convinced that the defendant can safely comply with conditions if released. Judges look at several factors when making this decision: prior criminal history, compliance with previous court orders, the seriousness of alleged violations, and the likelihood the defendant will appear for future hearings. In this case, two issues likely influenced the judge's ruling. First, the defendant allegedly failed to comply with the testing requirement, which is already a court-ordered condition. Second, there's the possibility of new criminal behavior, even if charges haven't formally been filed yet. Courts tend to view new allegations during pretrial release as a serious warning sign. What's interesting here is the defense argument. They proposed replacing SoberLink testing with a scram tether, which continuously monitors alcohol levels through the skin. In theory, that would eliminate the possibility of missed tests. But the judge apparently wasn't persuaded.
Probable cause conference is adjourned to July 17, 2025, 9 a.m. Bond will continue as denied at this point. She's sloughing off. That you are indeed guilty of these offenses?
Yes, I'm guilty of these offenses.
Okay. Starting with the case in the 14A2 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, I did.
What you're witnessing now is a formal plea hearing, and this is one of the most legally significant moments in any criminal case. The defendant here is openly admitting to possession and use of controlled substances, including cocaine and fentanyl. And notice how the judge carefully walks through a series of very specific questions. That's not just routine conversation, it's part of what's called a plea colloquy. Before accepting a guilty plea, a judge must confirm several things. The defendant understands the charges. The plea is being made voluntarily. There are no threats or hidden promises. The defendant admits to the factual basis of the crime. Every question you hear is designed to protect the defendant's constitutional rights and ensure the plea cannot later be challenged as invalid. Another critical part comes when the judge warns that if the defendant commits misconduct before sentencing, the court is not bound by any plea agreement. That means if the defendant gets into trouble again, the judge could impose a harsher sentence than originally expected. And here's a question worth asking viewers. Do you think admitting guilt in court like this shows accountability, or do you believe plea deals sometimes pressure defendants into confessing just to avoid harsher penalties?
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of, between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
People satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 14A2 matter, pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address?
I knew it. I was trying to sneak it in before you said something, Rushing. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so. No, count one is dismissed, except the plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
July 30th, 2025 at 12 p.m.
no. I have a sentencing. 9th, he's in custody. That's the date will be July 9th, 2025. Time?
9 a.m.
9 a.m. So you can come here and then get over to Judge Bar, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
It wasn't just he didn't go to community corrections. Isn't that correct?
that was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor to consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern for the people added to that is that prior to that, hearings in court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of saying to use of drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July 9th.
All right. Until I have an additional evaluation, I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each vote.
Thank you. Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell.
This final ruling brings the hearing to a close, and it ties together several important themes we saw throughout this courtroom session. Across multiple cases, the judge had to deal with very different challenges. A defendant experiencing what appears to be severe delusional thinking, another defendant facing bond violations and possible new allegations, and a third individual entering guilty pleas for serious drug offenses involving cocaine and fentanyl. In each situation, the court followed a structured legal process. For Mr. Miller, the focus was mental competency, meaning the system must determine whether treatment can restore his ability to stand trial. For Mr. Bromfield and Mr. Jones, the key issue was compliance with bond conditions and the court's confidence in their ability to follow the rules moving forward. What stands out in this hearing is how carefully the judge balances legal procedure with practical realities. Courts are not just determining guilt or innocence, they are constantly evaluating risk, accountability, rehabilitation, and fairness. Cases like these show the many layers behind everyday courtroom decisions that most people never see. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.